everybody, how's it going? Welcome back to Copper Jacket TV. So one of the most burdensome infringements on your Second Amendment rights has got to be these state quote-unquote handgun rosters, which are basically a list of items that the state says that you are allowed to have, as long as they meet their specifications, as long as they have their safety requirements, as long as they undergo their test, as long as the proper fees are paid and everything is done the way that the state wants it, then maybe you can have it. Again, it is a massive infringement on your constitutional rights. Well, thankfully, we have a new lawsuit that will nullify all rosters across this country. So let's go ahead and talk about it. Hey, real quick, if you're somebody who supports our God-given rights and our Constitution, consider hitting that subscribe button. It's free, it only takes a second, but it really does help us out here quite a bit, and it helps us spread our message. So thank you to everybody who has subscribed up to this point. Okay, so let's go ahead and talk about what's going on here, because this is a very interesting lawsuit. This is a lawsuit that was brought by the FBC. It's called Elite Precision Customs, LLC, VATF. And what makes this lawsuit so interesting is that it doesn't directly go after rosters at all, but a side effect of a victory in this case would essentially nullify all rosters across the country. So let me explain what I mean. Okay, so this lawsuit actually targets and challenges the federal ban on interstate transfers from FFLs to individuals. So for instance, when it comes to handguns, I can't go to being in Nevada, I can't go to Utah and get one from a shop there. It is against federal law. The only way that FFL in Utah would be able to handle that is to send it to an FFL in Nevada, in my home state, where the transfer would have to be conducted there. And so there is a ban on conducting that type of transfer anywhere other than in your home state. This challenges that ban. And if this were to win, it would mean that it wouldn't matter what state you would go to, you'd be able to get it from any state. So if I was a resident of California and this lawsuit was actually to succeed, I could then travel to Nevada, or I could travel to Utah or Arizona or wherever I wanted to, or if I was on a business trip to New York, I could get something there and simply bring it back, because it wouldn't have to go through that to FFL transfer. So from one transfer back to your home state and then onto the individual. It would get rid of that federal ban altogether, which again would nullify any roster, because if you have a roster in California, you could simply go to another state where they don't have a roster. Let me go ahead and read you just a little bit here from the lawsuit. Okay, so this is the introduction from that lawsuit, which basically tells you what the complaint is all about. It says, this lawsuit challenges the federal ban on interstate transfers of handguns from federally licensed dealers to individuals who are otherwise eligible to purchase and possess a handgun for lawful purposes, but cannot directly from a dealer because they do not live in the same state as the dealer. Under federal law, it is a crime for an individual to transport or receive in the state where he resides any firearm purchased or otherwise obtained by such person outside that state, unless the transfer was by bequest or interstate succession. Federal law also bars licensed dealers from selling to individuals who do not reside within the state in which the dealer's place of business is located. Now, what's interesting here is that this very unconstitutional ban that has driven me nuts for years, because I do travel quite a bit, and when I go to different states, I might see something that I like, but I'm SOL unless I do this whole transfer back and forth thing, and so I just choose not to. But it's a huge pain. But this was actually enjoined once. There was a case called Mance v. Holder back in 2015. That case actually won an injunction against this federal ban. Now, the Fifth Circuit ended up reversing that injunction in 2018 in Mance v. Holder. So we had two different attorney generals throughout this case. 2015 it was Holder, 2018 it was Session. So Mance v. Session was overturned in 2018, but they used the two-step approach. Now, since they used the two-step approach, they were able to come up with a reason to allow the federal ban to remain in place. Now comes 2022, and after the Bruin decision, they can't use the two-step approach anymore. And so the FBC has basically decided to bring this back to life, where the Supreme Court says that you have to look back in this nation's history and tradition of firearms regulation to find something that is relevantly similar that could uphold today's law. And there's nothing at all that's relevantly similar until you get to like the 1900s. Okay, so the 20th century. There's nothing until the 20th century that is even somewhat similar that could uphold something like this. It's well outside of Bruin's test. And so with that being the case, they've taken this lawsuit to court, or they've taken this lawsuit up, and they've decided that they are going to try and overturn this ban again, a ban that was already enjoined once. Now, I don't live in a state that has a roster, but I did live in California for 42 years of my life, and I can tell you that rosters are a massive infringement. It is really tough because they can basically put a stop to anything new coming into the state that they feel like, because all they have to do is add some new requirement to the roster, and that's it. Everything that goes onto that roster stops, like microstamping. Once they added microstamping in California, that was the end of anything new getting on there, because that technology just simply didn't exist. Nobody wanted to use it. It was very labor intensive. There was a lot of things that they had to do. And so obviously the roster was basically cut off at that point, and nothing new was added. And it's very easy for them to come up with new ways to add things that would again cut off the roster, even if it wasn't microstamping. This would essentially nullify that roster because it would allow people to travel throughout their country, right? You might be a resident of that state, but under federal law and under the Second Amendment, my right doesn't end when I cross state lines. So if I'm in California or I'm in Maryland, right, and I want to travel to another state and I want to get something in that other state, I should have the same amount of rights in that other state that I do in my own. And there shouldn't have to be any type of middleman that is involved in that whatsoever. And so this seeks to get rid of that federal ban that says you can't do that. And so it doesn't matter if you have a roster, you just go to another state and you'd be good to go there. And this would be huge, because even if you don't live in a state that has a roster, like I don't live in a state that has a roster anymore, it would be nice to go somewhere else that maybe had lesser taxes or something like that and be able to do business wherever I want. So again, this would be huge. And just based on the way that the Fifth Circuit's been ruling as of late, and the makeup of these courts changes over the years. So from 2015, even 2018 to now 2025, the makeup of the court looks different. And we've seen the way that they have sided on the Second Amendment in that court as of late. So again, this is really exciting, and I'm hoping that we actually get some good results in this one, because again, this would have a huge effect across the country for everybody, roster or not. But I wanted to share that with you, and I want to thank you all very much for watching. Please like, subscribe, and you guys have a great day.